Members of the Indian legal fraternity, we are running clean 1.5 hours behind schedule. So therefore I dispense with all the formalities. A very famous author, in his preface to the commentary on the American Constitution, commented that it is an intentionally incomplete and deliberately open-textured document for participatory evolution of democratic practices. Well, I think it's part of the lawyer's technique. Even the topic for today is like that. Public litigation policy, access to justice, and environmental law. And it is an open-texture thing. Anybody can read whatever he wants into this. Anyway, since all my predecessor speakers have touched various aspects of today's topic, I'll just narrate a short story to you and close it there. It is not a fictitious story, a story based on a case which I heard and decided. Sometime in the year 1975, Government of India decided to establish a thermal power station in the erstwhile state of Andhra Pradesh. They chose a location called Ramagundam, which is now part of Telangana. The then government, all of you know, NTPC is a Government of India undertaking. The then government of Andhra Pradesh assured NTPC that every possible cooperation would be given to the venture. Land was allotted, whatever other facilities, water supply and other facilities were made available. A huge extent, roughly, if I remember right, at that point of time, some 1,600 acres of land was allotted. Obviously, no industry is going to utilize the entire parcel of land the day one it gets possession of the property. It started construction in a particular corner and some of the infrastructure was developed. One of the requirements of these thermal projects is there's something called an ash pond. There's a lot of ash generated in the process of thermal power generation. An ash pond is required. A few years after the work commenced, the officers of the NTPC started digging up a particular area allotted to them for this ash pond. Then the Forest Department of Andhra Pradesh suddenly realized that this particular area where these people are carrying on this digging activity is part of an area notified to be a forest area by the Andhra Pradesh, under the Andhra Pradesh Forest Act. Immediately notices were issued saying that you are violating the law, you can't dig here, please stop it, otherwise action would be taken. And these officers of NTPC, they panicked obviously when they received notice, especially when somebody talks about prosecution, everybody is worried in this country. They rushed to the High Court. Initially, since it's an obligation by a Government of India undertaking, people who are in public service, obviously High Court thought it fit not to proceed with the prosecution of the matter, stayed the prosecution. The matter was pending in the Andhra Pradesh High Court for almost a decade. Eventually, the matter came to be listed before me sometime around 2005, 2006, just before the time I left Andhra Pradesh. I left in 2007. The matter was listed before me. And it was a bitterly fought case, both by the petitioners, that the officers of the NTPC on one side, and the state of Andhra Pradesh, the Forest Department, officers of the Forest Department. Government of India was a party. Why I chose this story is that it has aspects touching each one of the topics of the day. Public litigation policy, environmental law, its forest problem. Access to justice is a different story, I'll come to it later. Now, each one of the parties before the High Court was very vehemently arguing that they were right. And I must also tell you there's another aspect of the environment in this case. The amount of correspondence that took place in this case between the various organs of the state, NTPC, Government of India, Government of Andhra Pradesh, within the Government of India, Ministry of Environment, within the Ministry of Power, so on and so forth, I'm sure a few acres of forest would have been devastated for the paper used in this correspondence. Now, maybe out of sheer disgust, I told the counsel appearing for the petitioners, look here, there are two judgments of the Supreme Court, at least two judgments. This kind of a problem should not be brought to the court, an interdepartmental problem should be solved by referring the dispute to a committee of secretaries. I'm sure all of you must be knowing those judgments of the Supreme Court. Did you try this? They said no. Then I said, the Supreme Court clearly laid down that this matter should not be brought to the court. Why are you coming here? I'll dismiss it. Go and try that. Then the petitioner's counsel virtually started, not literally, metaphorically started crying. No, my lord, my officers will go to jail. I said, let them go. What is my concern? It's both the sides the governments are fighting. It's for them to settle. Then when the counsel still insisted, I said, look here, it's no part of my job to advise you as a judge, but I'll still advise you. Do one thing. If you're so afraid of it, going to jail, stop the activity, shut down the plant for a day or 2 or 1 week, whatever it is. Don't operate the ash pond. And you know what happens thereafter. Any government would crumble. If a power station is shut down for a week, any government in this country, local or national level government, will crumble. Try that. Everybody laughed in the court, but nobody was willing to experiment it. The point is this. This is a mindless litigation, and it's not a stray case. This kind of litigation goes on in this country every day, in many courts. But I don't understand. I can multiply the examples. If only I'm given time, in the next 10 minutes, I can tell you 10 examples which I dealt personally. It requires a clear policy on the part of the state. When you're talking, private litigants need not have a policy because they are individuals. They have no obligation to the rest of the society, barring moral obligations or legal obligations stipulated by the law. But in the matter of litigation, they don't owe any obligation. But state owes an obligation to the entire society to have a clear policy in the matters of litigation. Lot of avoidable litigation comes to the court all over the country. I think an occasion like this is the right place where all these matters should be appropriately deliberated and appropriate conclusions drawn and brought to the notice of the government so that the government can come out a more effective policy. Thank you.
Thank you very much, sir. We are certain that in the sessions that are supposed to come in some time, we'll be deliberating much on what has been spoken by you.